before we get started, anyone who hasn't met him, John, this is John Wiest from Wiest Law, Business Law, right? And then John works with our accelerators, a lot of our accelerators who already closed on some businesses, right, John?
Yep.
And usually from right after LOI through close.
Mhm.
And he'll be presenting. I believe this is the coverage of an attorney uh, during acquisition, right, John?
Yep.
All right. Well, all right, John. I'll hand it over to you so you can introduce yourself to them. And yeah, please say hi to John, everyone.
Thank you, everybody, for joining today. I recognize some of the names on the list of folks who have joined, and so happy to speak to you guys again, and hopefully you're not tired of hearing my voice. And the rest of you that I haven't met yet, hopefully we can chat someday. Yeah, this presentation is really kind of my, based on my experience working in M&A for many years and with Acquira clients and accelerators for over a year now. Kind of my key thoughts on what you should know about working with an attorney and an attorney's role in an acquisition. So I'm going to share my presentation, and I've given this similar presentation on these calls a couple times before, but hopefully you can still grab some benefit from it. Let's see. Okay, so let me just share that. And Andy, can you confirm that you can see the slides?
Yep, we can definitely see the slides.
Great. Yeah, so I titled this presentation 6 Key Questions When You're Buying a Business. And these are really questions that I, as an attorney, am going to be asking you on the first call that we have when you come to me and you say, hey, I've got a business I want to buy. These are kind of the 6 main things that I'm going to ask you about to help me understand your deal better, what your needs are, and how to get you to closing from that point. So just a little bit about me. As Andy said, my name is John Wiest. I'm the sole owner of Wiest Business Law, PLLC. I'm based out of Salt Lake City, Utah. I'm from Salt Lake City, grew up here. I went to Harvard for law school and graduated in 2015 and came back to Utah right after law school, where I worked at 2 international law firms with Salt Lake offices. I was first at Dorsey and Whitney, and then I was at Greenberg Traurig. And 4 years ago in 2021, I left big law. After it was a great experience. I learned a ton working for big law firms, working on really large cases and deals, but ultimately decided I wanted to do my own thing. So I started my own practice 4 years ago and have really zeroed in on M&A transactions for small, mid-sized companies. So I would say 95% of my practice is M&A work in deal size, maybe like up to $10 million. I'm very well versed in the space, have a ton of experience, and have really enjoyed working with Acquira folks. So I got connected to Acquira over a year ago, and I've helped a number of their accelerators close deals all over the country. And I think that Acquira does a great job of advising you folks on going through this entrepreneurship through acquisition process, which I had one person recently I had lunch with, he described it as drinking from a fire hose, trying to get a company under LOI and learn everything that he needed to learn. And I sympathized with him. I was like, yeah, it's a lot when you're trying to become an entrepreneur through buying another business. There's a lot that you need to know. And my job is to help you with all of the legal aspects of that process. So just a brief rundown of this presentation, the key stages of buying a business. This is kind of from my experience, what I see my clients go through these stages. So the first one, and which I think most of you are probably in right now, is in the searching and pre-diligence stage, where you're out there, you're looking for the right fit, the right kind of company, and researching a bunch and trying to figure out something that works for you in the right place and it's the right kind of business you want to buy and can see yourself running or owning. And then once you have found the right one, you submit a letter of intent. And if your letter of intent is accepted, then you're in a period of exclusivity. And so that is the next 3, due diligence, purchase agreement, and financing. Those are all steps that kind of happen simultaneously as soon as you have signed a letter of intent, because you should have a period of time where you are the exclusive potential buyer for the company, and the seller's like, hey, I'm not going to shop around anybody else while you take a chance to look under the hood of my company, make sure you want to buy it. So it's a really busy time for an accelerator, because you are first doing your due diligence. That's financial due diligence and legal due diligence. You're looking at all the financials of the company. You're looking to see that they're properly organized, looking at their contracts to see that they are what they say they are, and if you need to transfer them, that they can be transferred. And so you're working on that, and you have advisors helping you with that. You're also trying to get your financing lined up. You're self-financing or seller financing the whole thing, but most of you, I think, are going to be doing some kind of bank financing and probably an SBA loan for these a little bit smaller deals. And that's a long process as well. If any of you have ever gone through it before, it's pretty invasive as well. It's a good word to get a bank loan. So those two things are happening. And then the third thing that's happening is you are trying to get a purchase agreement in place between you and the seller. That's mainly what I help you with, is helping you to get, in an LOI, they may call it a definitive agreement, but it's a purchase agreement. It says, this is what I'm buying, this is what I'm paying for it. And we'll get into that pretty shortly here. And then, assuming everything goes well, you get to closing, the closing date, where you have a signed purchase agreement, probably signed in advance. The bank is ready to fund your loan on a certain day, and that is the date that you close. The seller gets their money. All the paperwork gets signed, the paperwork with the bank, paperwork with the purchase agreement between you and the seller, and then you own a company and you are on your way in the next steps of your journey. So, like I said, my main job is to help you with the purchase agreement. And so sometimes folks come to me and they say, hey, when should I hire an attorney? And most of the people who come to me, that get referred to me through Acquira, have already entered into an LOI. And that's totally fine. That's great if you want to, you don't necessarily need an attorney to help you draft an LOI. They're pretty formulaic. And if you've got great advisors like Acquira, I'm totally comfortable having somebody come to me with an LOI already signed. So, but sometimes folks want an attorney's opinion before they sign an LOI, and I'm happy to help with that as well. Help you, determine what the terms are, give some advice on, maybe some of the things that are going to go in there, like transition services or the amount of the seller note or something else like that. But I'm happy to come in before or after the LOI. And when you come to me and we talk before, I can, I'm happy to, I will have an initial call with you where we'll talk about your deal, talk about pretty much what I'm going to share in this presentation, which is the process that I go through of helping my clients get to closing. And so we'll have a conversation, and maybe you're talking to multiple attorneys, so that's great. Make sure you got the right person to help you with the deal. And then we'll sign whoever you choose to help you as your attorney in your deal. You will sign an engagement letter with them, and it will lay out the scope of their services. It says, this is what we will help you with, maybe some things that they specifically say we will not help you with, X, Y, and Z. And then it will lay out the fee structure, if they require a retainer up front, how much, if they're doing a flat fee or they're doing hourly rate, it will include all of that information. And so, I always tell my clients, like, I am legally engaged as your attorney, and we have created an attorney-client relationship once we have a signed engagement letter and I've received a retainer. That's what kind of locks me in, and from there, everything that I say to you that's just between the two of us is privileged. It's under the attorney-client privilege, and I have certain duties to you, ethical duties to advise you to the best of my ability and advocate for you. And that's what gets me working as your attorney. I also strongly advise that you have some financial and or tax advisors helping you with your deal. I know enough about taxes to be dangerous, but I'm not a tax expert. And so I would certainly recommend that you talk to, you have a CPA or another kind of financial advisor, first of all, to help you with the financial due diligence, looking at the profit and loss or Q of E, coming up with a QOV report, looking at the books of the company, and then also helping you understand the tax implications of the deal, which we'll discuss a little bit in more detail later in this presentation. So yeah, you have on your team, maybe your business advisors, folks like Acquira, maybe you have a CPA, another financial advisor, and you have your attorney. And also the bank will have somebody that's helping you meet all of their requirements for funding. So once you've chosen to engage an attorney, this is like, I will ask you these questions, well, probably on our first call, and if not on our first call before you engage me, definitely on the first call after you engage me. These are 6 key questions that I'm going to ask to help me understand your deal better. So just a brief overview of what we're going to talk about the rest of the time. Is it a stock or an asset purchase? Who's the buyer? Who's the seller? Tell me about the real property involved, if there is any. Tell me about your financing, and talk to me about net working capital. So we're going to probably spend more time talking about stock versus asset deals. Certainly talk a good amount about net working capital, probably a little bit less about real property, but we'll see how things go as we progress in this presentation. Okay, so yeah, the very first question I'm going to ask you is, are you doing a stock or an asset purchase? And I'm sure that all of you have looked into this, or Acquira has shared information with you about the differences between a stock or an asset purchase. But I like to just make sure from the very beginning, because this depends on this, the answer to this question helps me know how to draft the purchase agreement and what things to look for and how to advise you. And so like it's hard to describe the difference between a stock and an asset purchase to someone who's unfamiliar with the concepts and has never heard them before. And so I like to use kind of an analogy to help you understand the differences. And so I imagine that your company, imagine the target company is like a store, like a storefront on Main Street or whatever. And out front, it's a brick building, or it's standing alone. And it has a door inside of the store. It has a sign out front that says Acme Incorporated or Acme LLC. The name of the company is on the front. Everybody knows that that's the company. That's where they go to get the services or buy things from that particular company. And say it's been there for a long, long time, or in that exact spot on the street. And if you want to buy that company, then that's the target. You have 2 ways to do it. You can either buy the company itself, or you can buy everything inside of the company and move it into a new company. So the first one, if you just want to buy that building and everything inside of it, then that is what is happening in a stock purchase. So I'm going to say stock purchase. There are 2 main types of entities that businesses are organized as under various state laws. One is as a corporation, and a corporation, the owners of the corporation own stock in their corporation. And the other is a limited liability company, an LLC, and the owners of an LLC own membership interests in that LLC. Stock and membership interests mean the same thing for their respective types of business entities, and they have different tax treatments, which we'll discuss later. So I'm just going to use stock as to mean both stock in a corporation and membership interests in an LLC. So just keep that in mind. So if you want to do a stock purchase, it's like the store. You're buying the entire building and everything that goes inside of it. It's at the end of the day at closing, the seller is going to give you the key to the building, and you're going to walk up. It's going to be turnkey. You're going to put the key in the door, open it, walk in. You own that entire building and everything in it. So both good for good and the bad. So there are some pros to doing a stock purchase. One is simplicity. It's turnkey. You walk in, you're just a new owner of an already existing entity, an already existing building. You don't have to change anything to it if you don't want to. I imagine you will want to, but you certainly don't have to. There's no need to move any of the stuff out of the store, to somewhere else. There's no need to change the insurance on the building or anything like that. It's all in the name of the company. It's all in the name of the building that you have just bought yourself. So I've had one client whose deal actually didn't end up closing And he was doing an asset purchase, and he, at the end of the day, he said to me, after his deal ended up not closing for a variety of reasons, but he said to me, I wish I had done a stock deal from the beginning, because it would have been simpler. I wouldn't have had to set up a whole new entity and try and get all this, insurance for it, or various things. So for him, he looking back, wished that he had kind of done the simpler route, simpler legal route, which was to just do a stock purchase. So I thought that was very interesting. And so that's just something to keep in mind. If you're looking for simplicity, a stock purchase is a simpler way to do it. But the drawbacks of a stock purchase, and I think most people in this space, in the acquisition, the M&A space, will say, don't do a stock purchase, do an asset purchase. And there are very good reasons for that. And I'm not going to say one way or the other is the absolute best way. I think it really depends on the situation. But the reason people will say to avoid a stock purchase is, first of all, that you inherit all of the liabilities of the existing company, of the target company. So again, going back to the building analogy, let's say, so you just bought the whole entire building and everything in it. Let's say the plumbing in that building is really crappy and you have to repair it, the next year. You don't want to, or let's say somebody came into that store the year before, slipped and fell, and they haven't yet sued the company, but then after you buy that building, they come to you and they're like, hey, I slipped in this building, I'm suing you because I broke my, something, and you would have to deal with that as the new owner of that building. So there can be hidden liabilities to a company, and hopefully when you do your due diligence, you will discover any kind of things that maybe the company didn't do very well, or maybe they didn't make this certain payment they were supposed to make, or whatever. Hopefully you will discover those in your due diligence. And the purchase agreement should have language in there that protects you from those hidden liabilities to a certain extent. But if you just don't want to deal with it at all, if you just are like, I don't want to have any hidden liabilities whatsoever, then you don't want to buy that old building. You want to build a new building right next door, which is an asset purchase, which we'll talk about in a second. So another reason that that buyers and some sellers may want to avoid a stock purchase is that it's has a little bit less favorable tax treatment for the parties. So like you as a buyer, if you're coming in, you want to be able to, say you're buying a bunch of, say the company that your target company has a bunch of physical assets, that you would love to be able to depreciate those assets on your taxes and get some tax savings in coming years. If you do a stock purchase, and I'm just going to say this as, again, I'm not a tax expert or a CPA, but if you buy an already existing company, then maybe that company has already depreciated all of those assets before, and there's nothing left for you to depreciate. And so there are things you can do to, have a stock purchase be treated as an asset purchase, 338H10 deal or a 336E. Depending on the type of entity that you're buying. But again, those are extra hoops to jump through if you want to do a stock purchase. I will say that, in my opinion, the main reason to do a stock purchase is, let's say that the company that the target company, its most valuable asset, or the thing that you really want from this company, is that it has some really great ongoing contracts with customers. So I had one deal where I was representing the buyer, and the buyer was acquiring a commercial cleaning business in Colorado, and it was like a specialty cleaning business where this company was contracted to clean government buildings and like some military buildings and other things where they had to do some kind of specialized cleaning more than just like walking into an office and vacuuming and emptying the garbage. And so they had a lot of contracts with these government entities, and they were ongoing contracts where they came in on a regular basis and cleaned. That was what made the company valuable. That's how it got its income, its revenue. And the buyer, my client, wanted to have those contracts. Most government contracts have a clause in them that say service provider, cleaning company, you cannot transfer this contract to a different entity. So my client, if he had set up a different entity and tried to transfer those contracts into a new entity, the government agencies that were, on the other side of those contracts would have said, no, we're not doing that. And so he was like, I got to do a stock purchase because that's the only way to maintain the value of the assets for the entire reason that I'm buying this company. So in my mind, that's the best reason to do a stock purchase. And that can come up in a number of different, and I would say most government contracts cannot be assigned. There are other contracts that are difficult to assign. But for me, the number one reason to do a stock purchase is to, if you have contracts, the target has contracts that cannot be assigned and you want to maintain the value of those contracts. So that's a stock purchase. The other option you have, rather than buying the building and everything inside of it, is that you build a brand new building right next to the old one, a new storefront. Maybe it looks exactly the same. Maybe it's a little bit nicer, or let's say it just looks exactly the same. And you buy, instead of buying that old building, you just buy everything inside of it. You buy all of the furniture, all of the, if it has inventory in there, and you take off and you buy the sign out front with the name on it. You move all of that stuff next door into a brand new building. And so the pros of this is that you have a brand new building. There's no crappy plumbing. There's no, slip and fall that happened in the old building that could come and bite you in the butt. You have a brand new structure, and you've taken all of what in your mind is all of the valuable things from the old store, everything that was inside of it, and you've moved it into your new building. And so that's the pros of that are, again, no hidden liabilities. You are fully aware of everything that could possibly go wrong with your new building because you just built it. And you get more favorable tax treatment, like I was saying. So when you move all of the stuff out of the old building into the new building, you get to say your purchase price, just pick a round number, is like $1 million. And let's say that, some of the purchase price, you can allocate that purchase price to the various assets that you just purchased. And let's say you have a really, some piece of furniture and it's worth, you allocate $20,000 of that purchase price, saying that's what I paid for that, piece of equipment that's now in my new building. That is now your tax basis for that piece of equipment, and you get to depreciate that over the coming years and get more favorable tax treatment. So that's another huge reason that people will do an asset purchase. Like I said, you can make some tax selections that can have a stock purchase, treat it as an asset purchase, or you can just do an asset purchase from the get-go. Cons are what I was just talking about, transferring the assets. Let's say that you really loved the hardwood flooring in the old building. Well, it would be really hard to rip that out of the old building and put it into the new building. Or you loved all of the old, they were like antique windows or something, and that would be really hard to take those out of the old building and put into the new. That's like those government contracts that I was talking about. It's hard. It can be really hard to move assets from one company to another in certain circumstances. And so that's one of the cons of an asset purchase. So I think most of the LOIs let's see. Some LOIs that come to me, say somebody engages me post LOI, some of them are clear from the beginning. They say, we're going to do an asset purchase, we're going to do a stock purchase. They've already talked about it. That's great. I do get a lot of LOIs where it says that the buyer will buy either all of the stock in the old company or all of the assets of the old company, and they haven't yet made that decision. If you haven't made that decision pre-LOI, that is the very first decision that you should make from a legal standpoint before you move any further forward in your deal. So yeah, that's a really big deal, and happy to talk more about it if anybody has any questions on that. And please also, if you have questions, please raise your hand. I can't see the Google Meet right now, so Andy, if you see someone has questions, please stop me and let me know. Happy to answer as we go. Okay.
Yeah, I had a question on that last point. I think a lot of the time with my experience with Acquira and the stock versus asset, we do put that let's figure it out later clause in the LOI.
Yeah.
And so I'm curious as to why are you saying that is the first thing that should be determined before I even put out an LOI?
Because it really affects the structure of the deal going forward. You can't really draft any legal documents until you've decided on this. And so I'm not saying you have to have it figured out before the LOI, but it's certainly one of the first things you should figure out after an LOI has been signed. And maybe you need to do some more maybe you need to do some diligence to really make that decision, right? And so, you're starting due diligence, you're starting immediately right after the LOI is signed. So get into it and start talking to the seller about these questions of like, hey, is there any pending claims against you? Have you paid all of your taxes? You don't owe any back taxes? Like, that's something that you need to figure out pretty quickly, so that because otherwise it will delay the drafting of the legal documents. And also the bank is going to want to know this, because that's part of their risk calculation, is whether you're doing a stock or an asset purchase.
Thanks.
So, okay. All right. So the next question, I'm going to ask you, who's the buyer? So there are three main entities which can be a buyer or a seller in an M&A deal. One is you can buy, you can be the buyer in your own personal name. I could buy something as John Wiest. I would own it in my own name if I wanted to. I would only recommend that you do that if you are doing a stock purchase. So like if I was trying to buy Acme Incorporated or Acme LLC, I could buy the stock or the membership interests of the target company myself, hold them in my individual name, and I would still be protected personally from liability, because Acme LLC still exists as an entity, and if anybody had a claim against the business, they would sue the LLC first, LLC or corporation first. They wouldn't necessarily sue me. I could set up an LLC, a single member LLC, John Wiest LLC, if I wanted to buy the stock of the target company. That would give you an additional layer of protection, but I don't think it's really necessary. But if it gives you comfort, then go for it. It doesn't really make a difference. And that's the next one. So the company, if you wanted to form an entity to be the buyer, which I think is what the vast majority of people do, it can either be an LLC or a corporation. You don't have to do this if you're doing a stock purchase. If you're doing an asset purchase, you absolutely need to set up an LLC or a corporation to be the buyer. I would never recommend that an individual buy all of the assets of the target company and hold them in their individual name. That would give them zero protection from claims. If anybody had a claim against you and you owned, you were basically the company, they could take all of your personal assets if they got a judgment against you, which is not, we have LLCs and corporations to prevent exactly that situation. So if you're doing an asset purchase, you can form an LLC or you can form a corporation. And they have some differences. Corporations are much older, they've been around for hundreds of years. LLCs are a recent invention in the last 50 years, I think. In the 80s is when they started to become, states started passing laws about them. And they have a couple of key differences. So an LLC can have just one member, can have as many members as you want. Excuse me. And like I say, the owners of an LLC are called members. They're not called stockholders. They're members. They own membership interests in the LLC. One of the reasons that people like LLCs is that they are considered a pass-through entity in the eyes of the IRS, which means that the LLC itself does not pay any taxes on the revenue that it receives, the income that it generates. So you don't have to pay any taxes at the LLC level. The LLC will either pay wages or make distributions to its members, and then the members individually are taxed on those wages or those distributions on their own personal tax returns. So it's a good way. You only get one layer of taxation, but you do have liability protection in the form of an LLC. So I think that's a great option for asset purchases and also for real property. So if part of your deal is that you're buying a piece of real property along with either the stock or the assets of a company, I recommend holding any piece of real property in its own individual LLC. So if you were buying the assets of a company and say the building that it operated out of, you would set up two different entities. They could be owned by a shared holding company if you want. But yeah, definitely have any piece of real estate in its own LLC, because then if somebody has a claim against something happens on that piece of property, like a slip and fall, and they sue the owner of that piece of property, they're suing that one LLC. Its only asset is that property, and so a claimant's recovery would be limited to that piece of property and not all of the other pieces of property that maybe the owner of the LLC has, other businesses or personal assets. So LLCs are very easy to set up on really any state Secretary of State's website. And you can have an operating agreement, which is if there's more than one member in an LLC, I would definitely recommend having an operating agreement that sets out how you're going to run the company. It has some standard stuff in it about how taxation is going to work, and then some other kind of pro forma stuff. The other option is you can set up a corporation. And so then there are two main types of corporations, a C Corp and an S Corp. A C Corp is the default kind of corporation. So corporations are, like I say, an older type of business entity. They issue stock. And so you own stock in a corporation. You probably own some stock in, if you have investments in stock market or things like that. So a C Corp is the default type of corporation. And one of the reasons that people don't like C Corps, especially if you're doing a smaller deal where it's like a closely held company or things, is that the C Corp pays taxes itself to the IRS and maybe even to your state taxing authority. And then also all of its shareholders pay taxes on the dividends that they get from the company. So you're subject to double taxation if you do a C Corp. But why do people do C Corps? Well, the main reason is because they want to grow their company, or they want to have a lot of different investors, and they want to be able to easily sell their shares of stock in the company to somebody else. And it's very easy to sell stock in the C Corp. Like, in the stock market, people are buying and selling pieces of stock, which is tiny shares, maybe even large shares of ownership in a corporation very quickly. And it's just something that's easy to do. And so some folks that I've talked to, I'm just looking specifically at this audience, folks I've talked to who come to me from Acquira, maybe they're like, hey, this acquisition I'm doing is just the first acquisition of many that I plan to do. And so they're like, I'll do this one, but then later I want to bring in some investors that can help me acquire an even more expensive company or a larger company in the future. So they're looking to the future and they're like, I want to bring in investors. I want to easily give them equity in my company. A C Corp is a good option for doing that because it's relatively simple and easy to transfer stock in your company to somebody else. An S Corp, and I will also say that if you're looking like to sell your company at some point to maybe like venture capital firm or something like that, or private equity, they like C Corps best because it fits into their portfolio best, that there are fewer restrictions on who can own a C Corp, who can be stockholders. So it makes you like a favorable target to a future buyer, like a private equity or venture capital firm. So the other main type of corporations is an S Corp, which you've probably heard of. And to become an S Corp, you can either set yourself up as an S Corp, or you can later elect to become an S Corp by filing a paper with the IRS. And the benefit of a S Corp is that S Corps do not get taxed at the corporate level. So they get taxed similar to LLCs, where the corporation itself doesn't pay any taxes, just its stockholders pay taxes on what they get from the company. So yeah, you're like, oh, that sounds like the best of both worlds. Why doesn't everybody do an S Corp? The main reason that folks will shy away from an S Corp is because there are restrictions on who can be stockholders of an S Corp. That's really limited to individuals, certain trusts and estates, and single member LLCs. So like I had a client that they were a husband and a wife couple, that they wanted to buy a company that was an S Corp. And they had set up an LLC to be the buyer in their deal. But then they had to change that structure because if that LLC that had two members had tried to buy the stock of the S Corp, then the S Corp would have lost its S Corp status, because you cannot have an LLC with more than one member as a stockholder in an S Corp. So what they ended up doing was they ended up forming two single member LLCs that were then the owners of the stock and the S Corp. But that can be, again, if you're looking to bring on investors in the future, those investors are not necessarily going to be individuals who are buying stock in your company. And you're also limited to, I think it's like 100 shareholders. You can't have more than 100 shareholders in an S Corp. And you can also only have one class of stock. So if you want to give like various classes that give different benefits to different stockholders, you can't do that in an S corp. So those are all things to consider. What works best for you, it really depends on your situation, what your plans are for the future. You can change this later. If you bought your target company or the assets through an LLC and you later wanted to, form a corporation or something, you could sell. You just start a corporation and have the LLC sell the assets to the corporation. But that would, you'd have to change your insurance and everything else, all the other vendors that you used and get new bank accounts, et cetera, et cetera. So it can be done. But if it's a little bit simpler to just know upfront what you want to do. So as I was saying, I mentioned earlier, for most acquirer folks that I've worked with, they've set up an LLC for an asset purchase, or a single member LLC for stock purchase. Okay, so that's the buyer, and the next question is who's the seller, and this is very related. So if you're doing a stock purchase, then the target company is you're buying the target company and you're buying it from its current owner, which is likely an individual. So, Acme LLC was started by Jane Doe 20 years ago. She owns 100% of the stock, or she and her spouse own, half and half, or 49 and 51 or something like that. So if they own the stock individually in their own names, then they are the sellers in the deal. Or maybe it's a lot of sellers will have their company owned by their living trust, something like that. So this is kind of a technicality that I, as the lawyer, need to know how to draft the documents to know who is the person who actually owns what you're buying, because they have to have title to the thing that you're buying in order for them to sell it to you legally. I had an interesting situation just recently where my client was an individual, and he was looking to buy all of the stock of a membership interest in an LLC from a gentleman who had owned it. It was a painting company. And then sadly, while we were in the middle of negotiations, the seller passed away. And it wasn't completely sudden. He had been suffering from cancer for some period of time, but he passed away. And then we had to pause for a second on the purchase to figure out, okay, he owned the LLC before, now who owns it? And we had to wait for his estate to get probated and his daughter appointed as the personal representative of his estate, so that she had authority to sell the LLC. But it was I explained to my client, I'm like, we have to know who owns this company, so that you get, when you buy it, you have clear title to it, and somebody can't show up in a year and be like, my sister sold that company and didn't tell me, and I had a right to it, blah blah blah. So we were able to sort that out. It wasn't that big of a deal. But you also want to know, because we talked about the S corp restrictions on who can be a holder of an S corp, if the target is an S corp. And I forgot to mention something about LLCs. So LLCs can also choose to be taxed as an S corp. They already have the pass-through taxation, but it allows the LLC to then it gives you more favorable treatment on payroll taxes to have an LLC taxed as an S corp in certain situations. So you want to talk to a CPA more about that. But LLCs can be taxed as S corps. So if it is an actual S corporation or an LLC taxed as an S corp, and you want to maintain that S corp status, then you need to find out before you buy, and make sure that you are that the buyer is the correct kind of entity to be the owner of an S corp. So in an asset purchase, so that's a stock purchase. The seller is usually an individual or maybe a trust that owns the target company. In an asset purchase deal where you're buying all of the assets, you're just buying the stuff inside the store, not the actual store itself, then the target is the seller. It's, Acme LLC, you're buying all its assets. Acme LLC owns those assets currently. Acme LLC is the seller in the deal. So those are, this kind of stuff is usually, well known by the time you've got an LOI. But every once in a while, we have some things that come up, and we need to make sure that we understand this when we're drafting the purchase agreement. Okay. So I want to talk somewhat briefly about real property. So I would say, a lot of deals the target, maybe they have an office space. That's not uncommon. It's less common now than it was, say, before the pandemic. But if they have an office space or a warehouse or a factory, something like that, that is an integral part of the business, then you need to figure out how you're going to stay in that space. And so if the target, so there's kind of a couple ways this can go. Either the target company itself owns, like maybe the owners of Acme LLC also own an LLC that owns a different LLC that owns all of the real property, that owns the building. That's not uncommon. And so then either you buy that piece of real property from the target principal, from the owner of the target, or you enter into a lease with them. And I see both. Not everybody can buy a building at the same time they're buying a company, or wants to buy a building at the same time they're buying a company. But so they'll either buy it or they'll lease it. And that's if the target principal owns the real property. If a third party landlord, somebody totally unrelated to the target company, owns it, then you either can assume the current lease that the target company has, or you can enter into a new lease with the landlord. And some companies, though, don't even have a lease. They're totally online or totally remote, or it's a software company and all of the employees work remotely. Then you don't have to deal with a lease, and that simplifies your deal to a certain extent. If real property is a part of your deal, then I always tell folks in that situation, start talking to the landlord, whether that's if it's part of the deal and you're not buying it, you're going to lease going forward. You should really start talking to the landlord, whether it's the target principal or a third party, really quickly. I've had some deals that most landlords are great, and they're like, hey, this tenant's been in this space, I want to keep them in this space, so they won't really have a problem just entering into a lease with you. I think it's smart to get a new lease if you're doing an asset purchase. If you're doing a stock purchase, you probably still need to notify the landlord that you're buying this company, but you need to talk to them because you're going to be working with them going forward. Sometimes the landlord will be a real jerk, and they'll say, hey, this new person is coming in to buy this company, and they want to stay in my space. This is an opportunity, and they want a new lease. This is an opportunity for me to jack up the rent, to complain about repairs on the property that the old owner should have taken care of and needs to take care of before we'll close. You just never know. I've had some situations where the landlord was a real pain, and one, in fact, where he was basically extorting both the buyer and the seller to get all these repairs to the property. So if that's going to be an issue, you want to find that out sooner rather than later. It doesn't happen that often, but it can be something that happens. And just so you're all aware, usually I don't typically draft leases as part of what I do, because landlords usually draft the lease in the first instance, but I often help my clients review them, make sure that they're commercially reasonable, and then and if we need to negotiate certain things, we can. So, but that usually comes from the landlord in the first instance. Okay, moving on to question number 5. So I'm going to ask you about financing, and for folks from Acquira, the vast majority of the deals are SBA funded with a seller note. So it's a combination of bank financing, seller financing, and the buyers injecting a certain amount up front. So, and that's great. I've done a ton of deals with the SBA. It's a pretty invasive process to get them to approve a loan. It's not unlike buying a house, and they'll require the seller to give you some amount of financing, because that incentivizes the seller to help you post-closing, to make sure that the company runs, it doesn't tank after you take over, because if that happens, then the seller doesn't get paid on their seller note. So that's the thinking behind that. So if you're doing seller financing, like I just said, the SBA will require the seller it's typically 10%, give a seller note for that amount. One thing I want to flag for you guys is securities / collateral for your loan from the seller. So whatever bank you use to finance the bulk of the purchase, they're going to require you to give security interest and collateral, or synonyms. They want you to put up all of the assets of the company as collateral, personally to guarantee the note or the loan. I'll explain what that means in just a second. They're going to want probably you to put like your house or any other personal assets you have as security. And so like you're just like granting a security interest in pretty much everything. So the difference between, and I just said a security interest and I talked about a personal guarantee. So the difference between those two is a security interest is when you give collateral for a loan where you say, hey, if my buyer entity, buyer LLC, doesn't repay this loan, then the lender can come and foreclose on all of the assets of buyer LLC, take them, sell them at auction, whatever, hopefully get back some of their money, or the lender's hoping to get back some of their money. They don't want to do that. They don't want it. That's their last resort. But that's what it means to grant security interest in your assets / put them up as collateral. A personal guarantee is different. So in addition to wanting a security interest in the assets of your company, the lender is going to want a personal guarantee, which means owner, Jane Doe, owner of buyer LLC, you are also on the hook for the loan that we're giving to buyer LLC. You're not named as a borrower on the note, but you are promising that if buyer LLC stops making its payments on this note, on this loan, then we can come to you directly. We don't have to sue you, don't have to do anything other than come to you and say, Jane, buyer LLC is not paying its loan. You have to pay the loan on its behalf, and out of your own personal funds. So that's what a personal guarantee is. And every bank lender is going to require both a security interest and a personal guarantee. I will say that for like the seller note in a deal, a lot of times these LOIs come to me and they have the seller is going to finance 10% of the purchase price at 6 or 7% interest, whatever it is, over 5 years or 10 years, monthly payments, blah blah blah. But it doesn't say anything about whether there's going to be collateral securing this loan. Now, I've represented banks throughout my career, including gigantic banks when I worked at a larger firm, Wells Fargo, Citibank, etc. And I think any lender who gives an unsecured loan is a moron. Like, just flat out. I just think it's a really stupid thing to do, to give somebody money and not get any collateral in return. Now, that being said, if you and the seller have not already talked about whether you're going to give some collateral to their loan, I'm not going to mention it to them in the first instance. I'm not going to go to them and be like, hey, seller, you and buyer haven't talked about this yet. Like, do you want collateral for your loan? That's a job for their attorney to figure out. To see, so I'll draft the note and I won't put any security interest in there or personal guarantee. If the seller's attorney is worth anything, they will notice that and come back to me and say, hey, we have to put a security, we have to have security for this loan. And me as your attorney I will come to you and say, they're right. That's totally commercially reasonable. Every lender in the world requires this. So I'm going to recommend that you do it. So it's something that but I have had notes where the other side didn't catch it. It's not my job. It's not we haven't done anything wrong. But I've been kind of shocked, like, oh, they didn't want security. Well, that was pretty dumb of them, but it's not my job to look out for the seller's interest. So I just want to flag that for you guys, though, that if they do come back as I think that they should, if the seller's attorney is worth anything, and say we want security interest, want collateral, personal guarantee, I'm going to say to you, hey, that's pretty reasonable. I recommend that you grant that. Some folks have really strong feelings about that, and they're like, I absolutely don't want to do that. That's how you feel. We can push back as much as you want, but I just wanted to flag that for you guys as something that comes up. Okay, so the last question is about net working capital. I know we're coming to the top of the hour, and I want to leave a couple minutes for questions if you guys have them. So net working capital is by far the most fought over / negotiated part of a purchase agreement, if it is relevant. So what net working capital is you, as the new owner of a company, once you take over, hopefully there will be some accounts receivable or something that are already owing to the company that you can collect pretty quickly. But there's probably going to be some period of time where you don't have a lot of cash flowing in, but you still maybe have employees you need to pay, make payroll, or you have some other, pay vendors or whatever it is. You need cash to run a company. And so there's going to be a period of time, a couple months, however long it is, depending on the company, where you need to have a reserve of cash going in that you can use to run the company. There are two main options to do this. One is that the seller either leaves with the company if it's a stock purchase, or transfers if it's an asset purchase, some net working capital, some cash or cash equivalents to help you run the business post-closing. Now, psychologically for sellers, that's really hard because they're like, what? I'm selling you my company and you want me to give you $200,000 in cash or something like that? They're like, you're supposed to be giving me cash, right? And so if their attorney should, and their advisor should have, hopefully talked to them about this so it's not a total surprise. But that is something that's kind of hard for sellers to wrap their heads around. Now, it benefits them in the end because they've got a seller note that they want to get paid on. It's up to, it's in their best interest to help the company succeed post-closing. But it's just something to figuring out how much that amount should be is also very variable depending on the company. It's, it's AP, it's AR, how quickly it gets paid, whether it gets paid up front on things. And so I always like to tell folks, if they can negotiate this, or at least negotiate how you're going to calculate net working capital before an LOI, then that's great. But that often does not happen, and that's totally fine. It will be negotiated after the LOI. But that's a conversation that needs to start really at the beginning, right after the LOI is signed, because it's just something that people fight over a lot. So talk to your attorney, talk to your financial advisors about how to calculate the net working capital, how much you think you're going to need. And it really helps to have a good relationship with the seller. And hopefully they're a reasonable person and understand that you need some cash. The other option is to get a line of credit from your bank. That is simpler, in my opinion, to get, and a lot of banks are willing to do that. They're like, hey, I'll give you a $200,000 line of credit, whatever it is, to help you run the company, and then you don't have to get any net working capital from the seller. Excuse me. So my preference for, simplicity's sake is that you get a line of credit from your bank. And you may be like, well, then I'm paying interest on it, et cetera, et cetera. Well, you're also fighting with the seller and paying interest on their seller note. And so it kind of comes out in the wash, in my opinion. But, not everybody is able to do that or wants to do that. And so that's a conversation you need to have pretty quickly. So that is all of the 6 questions that I like to talk to folks about. Let me see if I can get this slide. So I wanted to leave, we have 5 minutes left. I just kind of wanted to see if anybody had any questions that I could answer.
I guess we don't have any questions. Maybe, John, you can send your contact information, or I'll send your contact information in the chat.
Yeah, here's my contact info.
Oh, there you go.
Yeah, and we can certainly put it in the chat as well. Let me I'll just log out of this and put it in the chat, and then you guys can copy and paste it really easily.
Yes, please. Thank you.
Stop presenting. Where is the chat? Let's see.
So feel free to reach out to John if you do have any. Oh, sorry.
Happy to chat with anybody. Shoot me an email, text me, call me. I'm happy to have a conversation offline about any of these questions. I like working with Acquire folks. You guys are great, smart, savvy people, and happy to help in any way that I can.
Cool. Thanks, John. This is a valuable session today. And I'd like to greet everyone in advance. Happy Thanksgiving.
Great. Happy Monday, everybody, and have a great Thanksgiving.